The entire issue of management companies in the healthcare world is a very complicated one. It involves a whole web of federal and state laws and regulations that affect who can own a healthcare business, who can provide services for a healthcare business, and how a healthcare business can pay for services. When it comes to management companies in particular, there are a number of very significant restrictions and limitations as to how a healthcare practice, a physician practice, or any other sort of healthcare business can pay for administrative services and for comprehensive management services. It's a subject that we're asked to work on all the time, and it's an issue and a subject that's very specific to healthcare transactions and one that healthcare attorneys need to be very familiar with.
Often the government deems the relationship between a medical professional corporation and a management company to be deemed as a suspect arrangement. The government, however, does indicate that there are some exceptions to this rule, and we call those safe harbors. And the safe harbors are as follows. 1, that the contract between the parties, must be in writing. 2, that the contract must be set forth for a period of 12 months. Although the parties have a right to terminate that agreement in less than 12 months, they do not have the right to renegotiate the terms of that agreement until that 12-month period of time has expired. The agreement must also set forth the amount of money that the professional corporation is going to pay to the management company. And that amount must be a fixed, flat fee that cannot fluctuate, and it cannot be based upon the amount of revenue that the medical practice is generating or the volume of patients. As a policy of our firm, we highly recommend that the professional corporation and or the management company, depending on who we represent, obtain a fair market value expert to determine what that fair market value is.